The UK Secondment Worker Visa is part of the UK Global Business Mobility Route. It was born on 11th of April 2022. For this type of visa to work, there must be two parties, the receiving party and the sending party, and there must be high-value contracts. What a high-value contract is, unfortunately, that is not defined by the immigration rules, and the Migration Advisory Committee suggested the 50 million threshold, which I personally think is too high. When preparing for this video, I've undertaken research and I found another .gov.uk website where they suggested the starting point of £118,000, which I think is probably more realistic and will enable more potential applicants to apply under this type of visa. This is a hybrid type of visa because it allows those with the UK presence in the UK to apply and those without one. It's a points-based type of application, and in this video I'm going to explain what requirements the applicants will need to satisfy in order to succeed in this application. I'm going to go through the procedural part with you. I'm going to explain the fee the applicants will need to pay, also the switching rules for those who would like to apply for this type of visa when they're already in the UK. We're going to concentrate slightly on the suitability requirements, and I'm going to show you how you can check if you meet all the suitability requirements. And finally, we are going to talk about the eligibility requirements, which consist of two parts because this is a points-based type of application. So there will be points-based requirements and a non-point-based requirements. So I'm going to explain in this video what those are. And finally, I'm going to explain what conditions are going to be imposed on your stay if the application is allowed, and what you can do if the application is refused, and also what will be the duration of your visa if it is allowed, and whether or not you will be allowed to invite your dependents, your spouse and your children. So let us begin. As with majority of UK visas, the applicants will need to meet the requirements in order to succeed in their UK Secondment Worker Visa. The validity requirements, the suitability requirements and the eligibility requirements. So let us look at the validity requirements first. When I explain this to students, I usually divide it into two parts, the procedural part and the no switching rules. So with the validity requirements, you have to remember these two bits, the procedure and no switching rules. The procedure is very simple and straightforward. As with all applications, the applicants will need to complete the online form, and the type of the online form will depend on where you're applying from. So for example, if you're applying from outside the UK, the application form which you'll need to submit is called Global Business Mobility Visa. If you are applying in the UK, it's going to be a Global Business Mobility without the word visa. So there is a tiny difference between these two applications forms. Both are online, which is incredibly handy, and you will be asked a series of questions in order to establish that you meet the validity, the suitability and the eligibility requirements, which I'll explain in this video as well. Secondly, you will need to pay the fee for the application, so they will not start processing the actual application unless you pay the fee for the application, and that is only £259 for the Secondment Worker Visa. And all applicants will also need to cover their immigration health surcharge, which is £624 per year for the main applicant, and if he applies together with a child who is under the age of 18 who is their dependent, it will be £470. That is a reduced rate. Again, this is per year. So if you're applying for 2 years, then you'll need to multiply this figure by 2. The next element of the procedure is to submit evidence of your age, your nationality and your identity. And from 1st of October last year, they stopped accepting the ID cards from the EU nationals. However, if you are an EU national, you can prove your identity with the help of this app, which is called the UK Immigration ID Check app. So if you are proving your identity with the help of this app, then you will get your digital visa. So it will not be even a physical document. You will get a digital visa, and you'll be able to travel to the UK without having a biometric residence permit or anything to confirm that you were granted visa. And of course, with all the applications, you will be expected to submit the supporting documents. And the supporting documents are very simple and straightforward. Predominantly, these will be the documents confirming that you meet the eligibility requirements, and you will understand which documents to submit after we discuss the eligibility requirements and how to meet them. The next part will be to submit your biometrics, which is going to be the scan of your face, a photo of your face, as well as your fingerprints. And for those who apply from outside the UK, if you are in the country which is on Appendix T list, and let me show you how you can find this. So if you go to your browser and you type Appendix T, you find the .gov.uk website, you open this particular appendix, and here you'll find the list. So if your country is on the list, or even if you are not from this country but you have been residing in one of these countries which is on the list for more than 6 months, then this means that together with your application, in order to meet the procedural parts and in order for the application to be valid, you'll need to submit a tuberculosis test together with the application. If you are from one of these countries, guys, but you were residing in another country which is not on this list, if you have been residing there for more than 6 months, then this means that you don't need to submit your tuberculosis test certificate together with the application. However, if you are a national of one of these countries and you have been residing in another country for less than 6 months, then this means that you will need to submit the tuberculosis test certificate. So just bear in mind this 6 months residence rule. These were our very simple and straightforward elements of the procedure. So they consist of 5 steps. Just to draw your attention here that the tuberculosis test certificate rules only apply to those who apply from outside the UK. In legal terms, these applications are known as entry clearance applications. In other words, this is for someone who is outside the UK and who wants to enter the UK. So that was our procedural part. And then we have the switching rules, which only apply to those who would like to make their in-country application. So they are applying for what's known a permission to stay or further leave to remain. It's also known as a further leave to remain application. So if you're already in the UK, you need to be aware of the rules. So switching is a legal process when you are changing the immigration categories. For example, if you came here as a student and you would like to remain here as a spouse of a British citizen, when you are making your application under Appendix FM as a spouse of a British citizen, you will be switching. So in this case, these rules may apply. However, if, for example, you came to the UK as a student and you would like to extend your stay and you would like to remain here as a student, then you will not be switching, you will be extending your stay. So in this case, these switching rules will not apply. So the switching rules are very, very simple. If you are in the UK in one of these immigration categories, as a visitor, as a short-term student, as a parent of a child student, or as a seasonal worker, or as a domestic worker in a private household, or if you made your visa application outside the immigration rules and it was allowed and you remain here in the UK lawfully, but the application was outside the immigration rules, this means that unfortunately, guys, the switching rules will apply to you and you will not be allowed to switch to the UK Secondment Worker Visa from these immigration categories. And this means that you will be required to go back to your country of origin and reapply from outside. However, if you're not switching and if it's not an in-country applications, the switching rules do not apply. So these were our very simple and straightforward validity requirements. And this is where the decision makers start considering your UK Secondment Worker Visa. So now let us have a look at the next step, the suitability requirements. And again, it depends whether or not you're applying from outside the UK or if you make your application in the UK. So let us have a look at the applications which are made outside the UK, which are known as entry clearance applications. For those who make their entry clearance application after meeting the validity requirements, you'll need to ensure that you prove to the decision maker that you meet the suitability requirements. And here is the way to check this. So if you go to your browser and you type Part 9 Immigration Rules, you need the .gov.uk website. So this will probably be the one. And then we need to jump to Part 9, grounds for refusal. And this is where you check if you meet the suitability requirements. In very simple terms, the suitability requirements are there to ensure that you are of good character and that you met certain rules. We can subdivide the suitability requirements into mandatory and discretionary, and they don't use the words mandatory or discretionary in their suitability requirements section. What they do, they use the words must or may. So when you open the suitability requirements and you see the word must, this means that these particular requirements is a mandatory requirement. So in other words, if, for example, someone was excluded or deported from the country and their deportation or exclusion order is in force, this means that the decision maker has no choice and they have to refuse the application. So the application must be refused. And let me show you a discretionary ground for refusal. So for example, if you have a unpaid debt to NHS, which is over £500, the decision maker has got a choice here. They can either allow or refuse the application. So there is a discretion, and therefore they are called a discretionary grounds for refusal. So when you look at this particular Part 9 of the immigration rules, you'll see that there are a number of suitability requirements on which the decision makers can refuse the application. But from my experience, the majority of these suitability requirements do not apply. But let me give you an example so that you understand how this works. For example, if someone has got a criminal conviction and was convicted of a criminal offense in the UK or overseas for more than 12 months, then it means that the application will be refused if you apply as a UK secondment worker. Or if someone, let's say, overstayed. So if you came to the UK and you did not leave the UK before the expiry of your visa, you became an overstayer, and also they may say that you've breached the immigration laws. And you have to understand that if you, for example, became an overstay in the past, it doesn't necessarily mean that your application will be refused straight away. It means that they will check if this paragraph applies. So paragraph 9.8.1 applies. For example, let's say you came here as a student and you left the UK after the expiry of your visa. So in other words, you breached the immigration laws, and they say that if you're making your application from outside the UK, so if you're making your entry clearance application, the application will be refused. So there is no discretion here. It's going to be a mandatory ground for refusal if paragraph 9.8.7 applies. So let us jump to paragraph 9.8.7. And here they say that if you're making your next application 12 months after you overstayed your previous visa, so if you left the UK more than 12 months ago and you left it voluntarily despite the fact that you overstayed and you didn't ask the UK government to pay for your return ticket, this means that you will not be caught by this paragraph. This particular paragraph 9.8.1 will not apply. However, guys, unfortunately, you may still be caught by the discretionary ground for refusal of paragraph 9.8.2. As you can see, we have the word may here, so this means that there is a discretion here. The application may be either allowed or refused. And according to this paragraph, the application may still be refused if you breached the immigration laws in the past. And even though they say here the paragraph 9.8.7 doesn't apply, so the table we just looked at, if the decision maker believes that you previously acted in a way which was to frustrate the intention of the rules, and there are other aggravating circumstances, or you failed to cooperate with the UK government before, or with the redocumentation process, unfortunately, in these circumstances, the application may still be refused. So I suggest that you jump to Part 9 of the immigration rules and you check if any of the grounds apply, and if they do, if there is anything you can do to rectify the problem. For example, if you have debt to NHS, probably it's worth repaying the debt before making your application. Or even if you cannot rectify the problem, for example, if you became an overstay in the past, at least you can submit a supporting letter explaining why you didn't leave on time. For example, if you were ill and you were unable to travel, maybe a letter from the hospital with the date as to when you were admitted to the hospital will help. So if you believe that one of these provisions apply, If it is a mandatory ground for refusal, there is no point in applying because the application will be refused. However, it's a discretionary ground for refusal. I strongly suggest that you either rectify the problem, or if you cannot do this, at least write a letter explaining why the application should be allowed this time. So these were our suitability requirements for those who make the application outside the UK. Those who make their application in the UK will still have to prove that they meet the suitability requirements. And in addition to Part 9 of the immigration rules, they have to prove that when they're making the application, they still have a valid leave in the UK. So they still have a valid visa unless paragraph 39E applies. And paragraph 39E gives some very small tiny exceptions for overstayers. For example, they explain that if you overstayed your visa, however, you made your next visa application, your permission to stay application within less than 14 days, and there was a good reason for you not applying before. For example, when there were circumstances beyond your control which prevented you from making your application on time, then, or the fact that you overstayed may be disregarded under paragraph 39E. However, as I said, it only applies for those who made the application within no more than 14 days after the expiry of their leave, and when they make the application, they provide evidence confirming that there are some exceptional circumstances. For example, if you were admitted to hospital or there was a very close family member bereavement. So if this is what's happened, you will need, together with the application and with your plea under paragraph 39E, you would need to submit evidence confirming that paragraph 39E applies. And when you make your secondment worker visa application, you should not be on immigration bails. These were our suitability requirements. The next one is the eligibility requirements. Guys, if the validity and the suitability requirements are almost identical for the majority of UK visa applications, the eligibility requirements are always going to be different. They are going to be the heart of this application, and therefore it's incredibly important for you to understand the eligibility requirements. Because the UK Secondment Worker Visa is a points-based type of application, the eligibility requirements consist of two parts: the points-based requirements and the non-points-based requirements. So if you make your application, first of all, you'll need to ensure that you can score 40 points for the points-based requirements. You'll be able to score 20 points for the sponsorship and 20 points for proving that your job is at an appropriate skill level. So with regards to the sponsorship, here's how you can score your 20 points. First of all, you will need to produce a valid certificate of sponsorship together with the application, which should only be issued within 3 months from the date when you make your application. So it should not be older than 3 months, and it should contain a certain information. The certificate of sponsorship should have your name and your job details. In this digital document, they also have to explain how much they're going to pay for your services and whether or not you have met the work overseas requirements. Also, it should have your contract details and whether or not Appendix ATAS applies. Let me show you Appendix ATAS. Okay, so if you go to your browser and you type Appendix ATAS, the .gov.uk website, this is the one you need, and they say here that you should obtain a valid certificate if you are applying in these occupation codes. In order for you to check if this particular requirement applies, you need to jump to Appendix ATAS, and if your occupation code is on this list, this means that you'll need to produce a valid certificate together with your application. These were the certificate of sponsorship parts, and then there are certain rules which apply to the sponsor. The sponsor will need to be A-rated, and they have to be registered with the Home Office, and they have to be licensed. The Home Office updates and their list on a regular basis, but probably the easiest way for you to ensure this is to ask your sponsor, because they'll definitely know whether or not they're A-rated, registered, and licensed. And then we have what I call the genuineness rules. And you may be curious as to what these genuineness rules are. Well, they are there in order to ensure that you are not making an application, that the sponsor hasn't invented this particular position only for you to enter the UK. So they would like to ensure that this job does exist and it's not a sham job, and that this job has not been created purely for the purposes of obtaining a visa to the UK. And also we have the third party rules. So in other words, the decision maker would want to make sure that you're not hired to a third party who is not your sponsor to fill a position with that third party, whether temporarily or permanently, it doesn't really matter, and that you do not work to undertake an ongoing routine role or to provide an ongoing routine service for a third party, again, who is not your sponsor. And this is regardless of the nature or length of any arrangement between you and the sponsor. So these were our genuineness rules. If you meet all three elements of the sponsorship requirements, you'll be able to score 20 points. Another 20 points you will get very easily if you prove that your job is at the appropriate skill level. And this is all about proving that, first of all, your job is listed at Appendix Skilled Occupations and it is eligible for the Global Business Mobility route. And secondly, that it is the most appropriate occupation code. So in other words, you'll need to convince the decision maker that the sponsor has not chosen a less appropriate code only because the most relevant job was not eligible for the Global Business Mobility route, or because the salary was higher for the most appropriate occupation code. And how are they going to check if the sponsor has chosen the most appropriate occupation code? There are a number of factors, and here they are in front of you. First of all, the decision maker will try and assess the appropriateness of the code by checking if there is a genuine need for you to undertake a particular job and whether or not you have the appropriate skills, qualifications, and experience for this type of job. And they will also be checking the sponsor's history of compliance with the immigration rules. So if the job at the appropriate skill level requirement is met, you'll be able to score another 20 points. Altogether, you'll be able to get 40 points for the points-based requirements. And as I said, you also have the non-points-based requirements. And we have these three parts: the overseas work requirements, the financial requirements, and the maximum length of assignment requirements. The overseas work requirement only applies to those who are making their application from outside the UK. So if you're already in the UK and you were granted a visa as a secondment worker and it is the same sponsor, these rules will not apply. But if you're applying from outside the UK, you will need to prove that you have been employed for your overseas employer for at least 12 months. There are certain periods of your absence from work which will be disregarded, and here they are. So if there were some gaps in your employment because you were on maternity, paternity, or adoption leave, then this will be disregarded. Or if you were on a sick leave, or if you were assisting with a national or international humanitarian or environmental crisis, provided this was with the agreement of your sponsor group, or if you were taking in the legally organized industrial action. So in these four circumstances, your gaps in the employment will be completely disregarded. Otherwise, you'll need to provide evidence confirming that you were working for your overseas employer for at least 12 months. The second one is the financial requirements. And again, it only applies if you are making your entry clearance application and not a permission to stay application where you remained in the UK for at least 12 months. If you are in the UK and you have been living here for more than 12 months, then the financial requirements will be met automatically. And also, there are circumstances where the sponsors are willing to sponsor the applicants. In this case, they will need to mention in their certificate of sponsorship that they'll be happy to sponsor you during your first months of residency in the UK. In all other circumstances, you'll need to show at least £1,270 in your bank account, and you need to show that this amount was there for at least 28 consecutive days. And the final non-points based requirement is called the maximum length of assignments requirements. It's a very simple one. The decision makers would like to ensure that you do not remain in the UK either on a UK Secondment Worker Visa or on any other global mobility routes or intra-company transfer routes. So this one died, but you may still have a visa which is called intra-company transfer route. So any period of time which you spend in any of these immigration categories will be taken into consideration when calculating your 5 period of time. So you should not be, as a result of you extending or making this application, you should not have remained in the UK for more than 5 years in any 6-year period of time. So if you have met the overseas work requirement, provided it applies to you, and if you met the financial requirements and the maximum length of assignment requirement, this means that you will also be able to meet the non-points based part of the eligibility requirements. So once again, 40 points for the points based requirements and 3 requirements for the non-points based part. If you meet the eligibility requirements, then this means that your application will be granted. If the application is refused, unfortunately, you have no right of appeal and you will only be able to apply for an administrative review. If the application is granted, then there are certain rules with regards to how long you can stay here. So, and it really depends on your circumstances. For example, the decision maker will grant whichever is the shortest from one of the following 4. So first of all, it's a 1 year after the start date of the job detailed in the certificate of sponsorship, or 14 days after the end date of the job, which is stated on your certificate of the sponsorship, or the date at which you will have had continuous permission as a UK Secondment Worker totaling 2 years, or the date at which you will have had a cumulative permission in the global business mobility routes totaling 5 years in any 6-year period of time. And of course, as with all other visa applications, there will be certain conditions which will be imposed on your stay here in the UK. So you will be allowed to work for your sponsor, you will be allowed to study, and you will be allowed to invite your spouse and your dependent children. So by dependent children, I mean those who are under the age of 18, who do not lead independent life and who depend on you emotionally and financially. You can do a volunteer job and you can travel abroad as many times as you want to. With certain exceptions, you will not be able to claim benefits. You can only work for the same employer, so you'll not be able to change the jobs. And as with all other UK global mobility routes, this one doesn't lead to settlement, so you will not be able to apply for indefinite leave to remain. Just to summarize, guys, when you are making your UK Secondment Worker Visa application, you will need to meet the validity requirements, the suitability requirements, and the eligibility requirements. Validity requirements are all about 5 procedure steps and ensuring that switching rules do not apply, and if they do, you are not caught by one of them. The suitability requirements is part 9, and ensuring that you're making your visa application when the previous one is still valid and you're not on immigration bail. And the eligibility requirements, these are points-based and non-points-based requirements, which we've just discussed.